Hi, good afternoon, everyone. This is Rajiv Eskhana for immigration.com, the law offices of Rajiv Eskhana PC. October 24th, 2013. This is a community conference call. The intention is not to create an attorney-client relationship, just to provide information. Um, that said, the first question today is from Dexter 2010. Came into the US in 2005, currently on 9th year of H-1B. Labor I-140, both approved, waiting to file 485. Now what has happened is that the client where he is working has offered him a position. And the position is good. Current employer has agreed not to revoke the I-140. So the questions are, assuming my client, the new employer, does a premium H-1B transfer and initiates perm process immediately, should I be worried about the delays in H-1B transfer? You see, here's what I like to do in cases like this. I like to wait to join the new employer until the H-1B is actually approved. You file premium processing, there is no reason why it shouldn't be done in a few weeks. Okay? So might as well wait for the actual H-1 approval before you join the employer. Based on my current approved I-140, can I assume that I'll get a 3-year extension? Yes, you will. Yes, you will. Will it be valid for 3 years from the current date or from July 2014, which is when his current H1 expires? So if you apply 6 months ahead, if you apply like in January, February 2014, you should get a full year's. If you apply now, I'm not sure how much they will give you. Government practice has not been consistent in this. Okay. So as long as the I-140 is not being revoked, that can certainly form the basis for ongoing H1 extensions. Will they give you the full 3 years? I certainly think so. But if you had applied, let's say in January, that's within 6 months of July when your H1 is expiring, they would definitely have given you 3 years. Average time for POMS appears to be a year. Should comprehensive immigration reform or some form of it pass in the interim, will I still be able to file I-485? I don't know. So far, every version of immigration reform that I have seen, it has not taken away a lot of the existing rights from employment-based applicants. It has given you additional option, but it hasn't taken away something which is pre-existing. And normally what happens is Congress does not necessarily like to disturb rights and expectations that are already conferred. So chances are you will be undisturbed in your 485. Will I need my old employer to give me an offer letter? That depends. If you are going to file through them, I don't really know. It all depends upon the circumstances. Since it's an employment-based green card application, do I even need an employer? Yes, you do. You do. To file 485, you need a job offer from the sponsoring employer. Am I required to join my old employer? No, that's a different question. AC-21 allows you not to join the future employer once I-485 has been pending 180 days after I-140 approval. Or let me rephrase that. I-140 is approved and 485 pending 180 days. So you were working for this employer. You joined the client. You filed 485 with the assumption that you will join the employer that you were working for. And then after 180 days, you can continue working with the client, no problem. Okay, you don't have to join the old employer. My work requires me to travel internationally 3 to 4 times a year. Can I go to Canada and get my H-1B stamping? Sure. Would it be safer to go to Canada as I'll be able to return to US even if something goes wrong? Who says that? Technically, if your H-1 is denied, you cannot use automatic visa revalidation to enter the United States. Okay, so no, that's a misunderstanding. But there is certainly some advantage to applying through Canada simply because they tend to be a little bit more reasonable in their investigation and expectations. So yeah, you can apply. GK001 says EB2 eligibility. EB3 priority date he already has. He's got a 3-year bachelor's degree. then a postgraduate diploma, and then he recently completed his MBA. But first of all, if your MBA is from an accredited university, then you should be able to get your EB2 for a job that requires an MBA with no experience, although or masters with no experience. Although these kind of jobs are a little rare because if you have just masters with no experience, is there really a good faith ground for rejecting any US applicants? Because I'm sure there's lots of people who've got master's degrees. Can I claim my experience acquired prior to MBA? The answer is yes. The interesting thing about EB2 through degree is that your experience does not have to be postmasters. Any experience, even pre-bachelor's experience, can be counted for a master's degree based EB2. That's not true for a bachelor's plus 5 based EB2, but this is true for master's degree based EB2. Anil Punjabi, documents that might work as alternative to birth certificates. I'm filing green card for parents. So mom and dad reside in Mumbai. They're visiting. Mom was born in India. Dad was born in Pakistan. First of all, be careful, Anilji. There should not be any preconceived intention when they entered that they are going to apply for a green card. Otherwise, USCIS can presume that the tourist visa entry was fraudulent. So be careful with that. With that said, normally what we do is for Pakistan, we give data from the Department of State website that shows that Pakistan and India are not on good terms, and you can't get documents out of Pakistan, so you cannot get any certificate of non-availability. For mom, you will need a certificate from the municipal corporation of the city where she was born to show that there is no birth certificate for her. That's called the certificate of non-availability. That combined with 2 affidavits each, one set for mom, one set for dad, that is given by people who were alive at the time mom and dad were born. That would be evidence of birth certificates. For relationship, if if there's a problem, we always say you can do our DNA testing. But for birth certificates and marriage certificates, marriage you can just give affidavits without anything more. But birth, you have to get certificate of non-availability, which is not really a typical certificate. It can just be a letter that says we have no record of birth for this individual. But you will need that and combine that with the 2 affidavits each, 2 for mom and 2 for dad. Actually, if you can, Mr. Punjabi, I would suggest you go ahead and get yourself a lawyer. It might make your life a little easier. These cases tend to get a little tricky. Raghav V says H1B and EAD transfer information. I'm working for company A on H1B, planning to get hired into company B via H1B or EAD. Can my previous employer find out about my new employer? No. It's not open to public in that way. Nobody can find out. So I'm not worried about that. SRA 101 says coming back to work in the US. So he had an MS degree from a reputable university in computer science, but he had to leave. So the question is, should he come back on F1 or H1? What is the best option? Of course, H1 is the best option. F1, unless you are going to genuinely go to school and want to get a degree, I wouldn't use that method. H1 might be better for you. Page 123, H1 amendment while H1 extension is pending. Well, let me clarify one thing for you. When an extension is pending, it's not really status. It is considered to be authorized period of stay. What does that mean? So when you're in authorized period of stay, your I-94 has expired, but you're legal, your extension was timely filed, you are okay to stay in the United States, but you can't change from one employer to another because you are not in full status until that H1 extension is approved. Okay, so there's a slight difference here from full status. So let's look at your situation. Current H1 I-94 expired 30th September, extension was filed June, so it was filed before expiration. Still waiting for my H1 extension. They are taking 5 to 6 months. Well, first of all, you should premium your H1 extension. That way, in a couple of weeks or 3-4 weeks, you've got your answer. Next month, I might be changing my client and job location. My employer would be required to do a new LCA and H-1B amendment. So can H-1 amendment and LCA changes be filed in this case? In this case, yes, I think so. And what happens is it's like a domino effect. So let's say the first extension is pending. Now you filed an amendment for the same employer. As long as the extension is approved and subsequently the amendment will be approved. Okay. But if the extension is denied, then the amendment will be denied for change of status. You may get an approval of the petition, which means you'll have to go outside USA for visa stamping. But for status purposes, unless all the intervening pending cases are approved, the ultimate case, like an amendment, will not be approved. Can the beneficiary start working at new client location as soon as LCA is filed and H-1 amendment is filed? Well, you can never start working as soon as LCA is filed. But can you start working as soon as H-1 is filed? I don't know. I don't think the law is clear on this issue. Because technically you are not in H-1 status. You are in, give me a second. I'm having a little trouble here. Some technical difficulties. One moment. I need to go into settings. My screen just blanked out. So give me one moment, guys. Okay, that should take care of it. So, can H-1 portability be applied that you start working right away as soon as this is filed? I don't know the answer to that question. I'll have to review the law very carefully, see what USCIS position in these kind of cases is. I don't think it's clear. Is it advisable to travel outside the US? If you don't have a visa, how will you come back? Normally, during an H-1 extension or transfer or amendment, travel is okay because you're not asking for change of status. When you have a change of status, you can't travel. But when you have just an extension, amendment, or transfer, there is no harm in traveling. But unless you have a visa stamp, how will you come back? If H-1 extension is approved while the beneficiary is outside the US and is required to go to consulate for H-1 stamping, what are the chances of H-1 stamping? Nobody knows what the chances of rejection or approval are. H-1B visas are not easy to get these days, especially when you have client-side placement. Fifth question, assuming my H-1 extension is approved and I get my new I-94 and my wife subsequently travels to India, can the consular officer reject her H-4 because I don't have a visa stamp? That depends. Consulate can genuinely require you to go get a visa stamping as well. But these days, at least, I haven't seen that happen too frequently. Question number 8 from Phukre. He wants to extend his small business in India and test the US market. You will have to do a B1 visa. A B1 visa. Okay. What you will do is you will approach the consulate. You send a letter to the consulate explaining who you are, what your business is, and that you are sending somebody just to explore the business of setting up investment consultancy in India in USA, and make sure they understand that this is not a job. The person who's being sent continues to get paid in India, and whatever you pay them in USA is just for their expenses, but their salary continues to be paid in India. You can try. B1 visa is the only thing that can work in this case. BSAC, last name issue in green card. So here what happened was there was no last name, then they got a last name. So, but now there's a little bit of discrepancy because the green card has been issued with no given name. So is this a USCIS error? Look, if you asked for a correction and they did not make it, that's a USCIS error. I would suggest you do one of the two things. Either take an InfoPass appointment, go downtown, or first call the USCIS customer service and see what they suggest in a case like this. If the name was correct on the I-485 papers and they gave you a wrong name in the final green card, that's a USCIS error. But if the name was not correct in the papers, then you should go ahead and file an I-90. Okay. Um, my wife is outside the country. She has an advanced parole valid till July 2014. Her green card has been approved. Can she enter USA anytime? Well, this has happened to other people as well. Again, there is no clear law on this issue. But typically, if you are on advanced parole and you're outside USA and your green card gets approved in your absence, USCIS does let you, not USCIS, CBP does let you enter, because using your advanced parole, they can check and confirm that in fact your green card has been approved. So far I have not known anybody to have trouble. You can double check with the CBP from cbp.gov, Custom and Border Protection. They actually answer phone calls. There might be even a frequently asked question on this. You can also get her green card, physical green card, delivered to her by hand, and she can use that. I'm not sure how illegal or legal that is. Seems legal to me. But that's certainly an option people have done as well. So she can enter on her advanced parole, or she can enter her green card, whatever gets delivered. And does she have to enter before July 2014? Probably not, because whether she enters today or 3 months later, she's still entering on advanced parole, right? So personally, I don't think this is a problem, but you should double check with the CBP, okay? I am primary applicant now working with Green Card Sponsoring Company A, offer from Company B, filed AC-21 just before the GC approval with the intention of working for them, but the green card was approved. But it's going to be a couple of months before I can join Company B. Can I continue working with Company A? Sure. I don't see any problem with that. What you should do is just document the fact that an AC-21 letter was filed, the contents as well as delivery, and if 5 years down the line a question comes up during citizenship, you have an explanation. I think you are just fine. A letter from Company B that says, okay, you can join us in 2 months, that's okay too. Okay, that will help as well. So yeah, keep that as well. Just keep that in your records in case it comes up during naturalization. I don't think it will though. I have had other clients in this situation and they've all done fine. JK time, AOS for myself and wife filed separately. So he filed for his AOS back in 2007. Then the priority date became current again with the September 2013 visa bulletin. AOS was approved September 5th, and I got married in 2011. I filed my wife's AOS in September. Look, that's fine. Remember, the law is not that you have to file her AOS before yours gets approved. The law is that you should be married before your AOS gets approved. You should be married. Okay? So there is no problem. I don't see any issues here. I'm afraid if there's something wrong in my filing and USCIS decides to reject the application as incomplete, she's currently on F1 visa, you can refile her 485. Okay. Following to join can only be done up to 6 months after marriage. No, not at all. Not at all. We have done following to joins, for example, in doctors' cases where somebody has got a 2-year home residency requirement. Her spouse got his green card, but hers was filed 2 years later as following to join through consular processing, which is perfectly okay. As long as you are married when the 485 or consular processing is approved, the spouse is entitled to following to join, and they are so entitled until you get your naturalization. Once you get your naturalization, she can't follow to join, but you can then apply for her I-130 separately. We both need to travel to India for an important family function. If AOS gets approved, well, listen to my discussion before in the question prior to that. AOS gets approved, she will be able to enter on advanced parole. I don't think they're going to expedite on these bases. Our applications are also in separate service centers. That doesn't matter. Deep MACT. Deep says, look, I was on L1B. I have a kid born in US. So how can I make sure that the kid can stay legally in India? Look, this is a question about Indian laws. I have no clue. You're going to have to talk to a lawyer on the Indian side. Second question, if my L1B from current employer gets denied, how long do I need to wait before I apply for H1B stamping? Not even one day. You can apply the very next day. There's no waiting time. Houston Krishna, now that's a name I have known before. Okay, parents are finally getting green card after 2 RFEs relating to birth certificate. They are in USA for at least 1 year. Krishna, what you need to do is, I have 3 or 4 videos in my blogs on maintaining green card. Real quickly, I'll tell you what the law is. I won't deal with all your questions because they're all dealt with in my blog. Bottom line is, your legal home must be in the United States. By legal, I mean, let me rephrase that. Your home. This is not a legal mumbo jumbo. Very simply, I ask you, Shri, where do you live? You don't have to think 15 times and do 10 calculations to give me an answer. You say, I live in USA, because that's where you in fact live. It's as simple as that. If you ever leave USA, abandoning your permanent home in the US, they can take away your green card. Of course, you can apply again if they take it away. But more of this is in my blogs. I have 3 or 4 videos quite extensively dealt with. Okay, so go review those. Rajesh K71. Oh, by the way, Krishna, also review I-131 videos, which is re-entry permit. Okay. Is H1 visa transferable across companies? Sure, Rajesh. That's exactly what it is. So if you enter on your brother's company's, no, let me rephrase that. Your situation is a little bit different. So your brother's company gets H1 filed, approved, you get your visa stamping, but you don't come to US. Can you use the same H1 to enter the country if some other company files for H1? You can't use the same H1 visa. You shouldn't. Consulate has been saying they don't like that. Okay. Under other circumstances, you can use the same visa for different filings. So let's say you entered in US, you started working for your brother's company. Then while you are in USA, a month or 2 later, you wanted to change over to another company. You can change over. Once you get your change of status, you can start working and you can use the same visa for travel. But in cases where you never joined the company who sponsored you, Consulate actually wants you to enter USA with the visa of the next company. But it will be a transfer. It won't be subject to a quota. Okay? As long as you've not been outside USA for more than 1 year after the H1 was approved. If you've been more than 1 year, then it's a little bit more complicated. You can still be out of the quota, but you got to do some calculations. Something called remainder option. Your lawyers can help you decide that. But yeah, transfers can be done. Anna wants to know, aloe vera 2. 6th year of L1B, H1B with perm filed less than 365 days before visa expiration. Do I have options? People do tourist visa. People do student visa. Those are the 2 options people use the most, Anna. Just remember, you're not allowed to work. Some people, they take a student visa and they get CPT and they start working. Usually, USCIS has been coming down hard upon these CPTs because they feel that universities that offer CPTs in the first semester are just EAD factories. Okay, so even though you have a B1, B2 visitor visa, Anna, you will still need to change status. You can of course go out USA and come back using your B1, B2. That gives you H1, B1, B2 status, or you can do change of status while in the United States. We have actually a bunch of blog entries on this to change status to maintain, to change to B1, B2 status to maintain your status in the United States. So you can look those up. If you are on the call right now, if you have any specific questions, I can try to answer them. But B and F visa are the options people use a lot. Sam says, Sam's 22, immigration records, there's a typo of the marriage date. This was, I guess, 5-6 years ago. Should we get the year corrected? I don't think you can do anything at this point of time. Apply for citizenship, attach a letter, stating that we have noticed during this paperwork that there's an error in our paperwork. Please correct this in our naturalization records. And I think that would be the right thing to do. Hari underscore 0604 L1 to H1 change of status. I have L1 with company A, H1 petition approved with B. If I apply change of status from L1 to H1, do I need to apply for a new H1? No, you'll be using the existing H1 to be out of the quota. How much would be the cost? I don't know the fees. Our team does all that work. My company A, which is the L1 company, has notice period of 3 months in India. Do I need to serve 3 months notice in US too? I don't know. That's the issue of contract law. As soon as my status changes, under immigration law, there is no notice requirement. Under contract law, that's a contract lawyer's job to tell you. As soon as my status changes to H1, I can't work legally with L1. Correct. Will my company A can stop giving me experience letter, etc.? They can. Yes, companies can. They are not required to give you an experience letter. Then you have to prove your experience through secondary evidence, like affidavits from co-workers and H1 papers, etc. Okay. Anjana Singh, N400 citizenship. After submitting N4 application, N400, travel outside for 1-2 months, is that a problem? No. As long as you're not going away for good or abandoning your permanent residence, if you're just going away for 1-2 months, no problem. As we know, N400 has a 90-day state residency requirement. Let me clarify something here, Mr. Singh. Many INS sub-offices, USCIS sub-offices, allow you to collect those 90 days while your N400 is pending. So let's say I move to Baltimore, Maryland today. Okay. And I file my N400 today. I don't have 90 days yet. But by the time they start dealing with my application, 3-4 months down the line or 5 months down the line, I would have 90 days. Some sub-offices allow me to do that. But others say no. You must have 90 days of residency before you file the N400. Always good to confirm it with the sub-office. How do you do that? Call the congressman for the area. Have them confirm from the USCIS sub-office if they will allow you to collect the 90 days. I'm not aware that there's a national policy. I know that we've had problems with 1 or 2 sub-offices, but others have allowed it. Traffic violations, do we have to mention them? Just read the N400 question. That should be quite obvious. Name change causes delay. It can. How much? I don't know. It depends upon the name check. I really cannot predict. But not all cases are delayed. Again, inconsistent, difficult to answer. But I think you have 2 options. Either get naturalized, then do a name change, or do a name change first, which I think is a little easier in my view. SG22, GC process continuation if not in the US. Okay, I've been in the US for over 6 years. H1 is approved, work on EVC model, employer vendor client. Waiting for the PD to be current. Now he's got Australian permanent residency and he's got to go. If I go to Australia now, would that impact my green card process even if I'm not in the country? It can be tricky. There are 2 things I worry about. 1, employer's ability to pay wages. You can discuss it with your lawyers if you are not on their payroll. And 2, is there really a permanent job if you're not working on it? So those 2 things are factors that can become problematic. Can I file 485? No, you have to be in the US to file 485. You can do consular processing. You can't do 485 outside USA. Can my H1B employer continue with my green card, or Do they have to revoke my I-1? They don't have to revoke your I-140. There's no law that says they have to. But most employers, including most of our clients, we advise them to revoke the I-140 because otherwise their burden of ability to pay wages becomes heavy. Because they have to have the ability to pay wages of every green card filing that they've done. Okay. Immigration reform, I don't know what's going to happen. I would advise you to follow my tweets, download our apps. If you type immigration.com in the search window on uh, Android as well as iOS, which is Apple system, just type immigration.com, the dot, not the DOT word, but dot, immigration.com. You should be able to pull up our apps. You can install those. They are free apps. You can also follow my tweets. My Twitter handle is at immigration.com, no dot, at @immigration.com. I try to keep everybody updated. In our new website, actually even on our old website, on the immigration reform page, in the right hand side, all my tweets are showing up. So you can follow the tweets there. I keep track of all that is going on. Politics is very interesting. We have a video of my radio show, which I do every Thursday, I think, Wednesday or Thursday. I usually talk a minute or two about immigration reform status there as well. So take a look at it. Right now, we don't know what's going to happen. But one thing is for sure, one thing encouraging is that there is a lot of agreement about need for legal immigration reform. Disagreement is about undocumented people, but not about legal people. Raj IMG says, I'm on H1 status, 11-year no stamp since 2002, changed employers 3 times. I've got one concurrent and one regular H1, okay, one part-time, one full-time. If I leave the country for stamping, do I have to show and submit all H1? I'm not aware of any such requirement. This is an interesting question. You can, of course, send an email to the consulate and see what they want you to do. But no, there is no requirement that says you have to disclose or talk about all H1s. Not that I know of. But send an email to the consulate, see what they say. I have an approved I-140 for whom I don't work. There's another green card going through another labor is going on. Now another employer, so can they file another labor while this one is pending? Yes. You can have 20 labor certifications, perm applications through 20 different employers. You just can't have more than one through the same employer for the same job. Is it safe to travel to Puerto Rico? I guess you mean Puerto Rico. Okay, the spelling is not correct. Puerto Rico has a strange relationship. Technically, you don't need a visa to travel to Puerto Rico. To come back to USA, you don't need a visa. But they can ask you as an entry, they can look at things that they normally won't look if you are going, let's say, within USA. So do you need a visa? You shouldn't need it. You should not. Okay. Seshan Srini says, I have a question on EB2 classification for Indian chartered accountants with 3-year degrees. So you have a BCom, then a chartered accountancy. You know, I haven't looked into this issue for a while, but the last time I checked, this is the history. Administrative Appeals Office, AAO, first said a CA is not equivalent to a degree because it's a training, it's not a education. Then 1 or 2 cases they approved a couple of years later. Their current position, as I remember from about a year ago, seems to be, and this was in relation to both cost accountancy as well as chart accountancy, they said, because the issuing organization is not a university or a college, we don't accept that as a degree. So this is, I think, their current position. Single source interpretation, I don't know what you mean by that. I can tell you this. The weird thing about EB3 and EB2 filings is it's easiest to explain it in the 3+3 combo situation. So you have a 3-year bachelor's degree in computer science, then a 3-year master's of computer applications from India, from a university. This is a 3+3 combo. You cannot combine these degrees to come to a 4-year degree for EB3, but you can combine these degrees, 3+3, to come to an EB2 because you have a master's degree equivalent. Very odd situation. Smile Baba. Future, okay, this is the last question, then we'll start on follow-ups, okay? Future GC without AC21. Worked with company A for 5 years. I-140 approved. April 21, okay, so she's got the visa second time, okay. So family is here. Now in April 2012, wife and I both filed 485 with the consent of employer A, even though I had moved to company B, I guess. So filed as a future employer. I-485 got approved recently. Can I safely continue to work for company B and not join my GC sponsor company A? Not filed AC21. Very difficult to answer this question. I'm not sure I can answer it easily. But I've already had this discussion earlier in a slightly different context. If you had filed AC21, there would be no problem. Because you've not filed AC21, let's see, 485 was pending more than 180 days. What I would do is, personally I don't think you would have, this is my opinion, this is not a fact. In my opinion, you do not have to join the future employer as long as you can prove, if asked at the naturalization stage, number one, that you were working on a same or similar job as described in your green card application, even though you were working for a different company, and that your green card was approved after 180 days of 485 pendency. So if you keep a job description, etc. handy from the future company, rephrase that, from the company B where you are currently working, to show that these are same or similar, I think you'll be fine. Yeah, I understand that you never worked for a petitioning company after filing 485. I think if you maintain records that show that the jobs are same or similar, and you know that 180 days passed, that is of course obvious from the paperwork. I don't see why you should have a problem. You should look at the Bill Yates memorandum of May 2005. There's a similar question, specific question, exactly like this. It says, well, I filed a 485 through a future employer. After 180 days, do I have to join them? And the answer is no. You can do an AC21 with any employer without joining the sponsoring employer, which is your situation. So look at the memorandum of May 2005. There was only one memorandum from Bill Yates. It should be there on USCI's website as well as on our website. Okay, guys, any follow-up questions on what I have discussed, please press *5. Any follow-up questions? No new questions, only follow-up questions. 1, 2, 3 raised hands. 4. Okay, press *5. I have 4 raised hands so far. Okay, 5 raised hands. I'm going to start in the order in which people logged in. Let's start with area code 570 from Pennsylvania. Go ahead, please.
Yeah, hi, Rajesh.
Yeah, I can.
Number 7.
Number 7. Okay, just a second. H1 amendment while extension pending. Go ahead.
Yeah. So basically, you mentioned that there are certain aspects of the law that which needs to be clarified. Now, one thing I wanted to clarify is the travel outside of US allowed if, let's say, the H1 extension is pending and there is a possibility that there might be a RFE? Like, does the RFE have to be answered while the beneficiary is in US, or can he be outside US?
He can be outside US. No problem.
Okay. Okay.
All right.
And about the other law, about the amendment, Rajiv, what do you want me to send a mail? You mentioned that it is still not clear
No, I'm not going to
reads.
look. I'm not going to spend an hour looking over the paperwork. You should have your lawyers take a look at it. You know, because this needs to be researched. I can't tell you off the top of my head what USCIS thinks about this. Personally,
Okay, it's not an easy
no,
thing.
I
Okay,
don't think
got
it can be. I don't think it can be done. This is just my memory.
Right.
But remember, the immigration law is very complex, and one should never definitively talk from memory without looking at the law. So have your lawyers look it up. I don't see any need for you to hire a lawyer for this. Okay. All right. Good luck.
Thanks.
Area code 646, New York. Go ahead, please.
Hello, Rajivji. Good afternoon. My question is regarding comment number 2. I joined the conference room late because of the confusion in the dial-in number. I was wondering if you'd be kind enough to just repeat the answers.
Well, look, I'm not going to repeat the whole discussion. You have to listen to the recording for that. But let me see what your...
Sure.
What I said was, don't join the client until the H1B is actually approved. What I also said was that I think you should get a 3-year extension, but there is some doubt about that. Would CIR hurt you? I don't think so. I think it can only help. Do I have to join my old employer if the green card comes through? It's a very difficult question to answer. If before 180 days, I would say that is probably a good idea. Can I go to Canada for visa stamping? That is no problem. Okay, you don't have to go to your home country. But it's not guaranteed that you can re-enter USA. You cannot use automatic visa revalidation if your visa is denied. Just remember that. So if that is your consideration that you'll be able to re-enter, that's not a good bet. However, overall, Canada is better than other countries because they are more reasonable in their investigation, most cases. Okay?
Excellent. Thank you, Rajivji.
You're welcome. Good luck.
Thank you.
Escondido, California. Go ahead, please.
Hi, Rajiv.
Hi.
Sorry, just a quick follow-up question, number 19.
19. Give me a second. Go ahead.
So I guess my question is that, is it safe to go based on currently?
Okay, I cannot hear you. Your voice is breaking up. I think what you're asking me, is it safe to go to Puerto Rico? I think so.
No, safe to go to India for stamping while the labor is pending.
Oh, labor pendency has no bearing on H1 stamping. It's absolutely no problem. Hello, can you hear me? You may want to call back in. I don't think anybody can hear you. Call back in, perhaps from a landline or a different phone, and just press star 5 again, okay? Atlanta, Georgia, go ahead, please. Atlanta, Georgia. Hello. Even your voice is breaking up. Today is one of those days. Can't hear you. Okay, Jersey City, New Jersey.
Hi, yeah, this is Samir, Mr. Raji.
Yes,
and
sir.
this is regards to that question, question number, sort of, the number 18
Okay.
down below. So, yeah, I mean, you mentioned, I was listening to you, and you mentioned that, going to Australia at this point of time might be a problem.
No.
And you said-
Wait. Let me clarify a couple of things. I don't think it's a problem. As long as you can focus on two things. One is a very normal question. Green card is based upon a permanent job offer. Okay. If you're already working on that job, how can it be permanent? How can they let you go? Unless the company is big enough or the workload can be moved over or you are working for them remotely. I mean, that could be a genuine question that could come up. It doesn't usually, but be prepared for that.
Okay.
Number two,
All right, sir, but
number
Go
two,
ahead.
if you're not on their payroll, up until the time you get the green card, the question of ability to pay wages can be raised again. They are supposed to pay you, let's say your salary is supposed to be 90,000 and you're not getting paid a single penny, then their tax returns must show that they've got that extra money to pay you. Okay. But going by itself is not an issue. I don't see it as a problem. USA is not the monitor of the whole world. USA should only be concerned about your intentions in the United States. What should they shouldn't care whether you have permanent residence in Australia, Canada, and New Zealand at the same time. That's none of their business.
Okay. All right, sir. So the point was that if I do go at this point of time, my H-1B, which is actually, as I said, is already above 6 years, and the current extension is based on approved I-140. So if I do go, would my extension be still valid, or my H-1B extension, because I would not be having salaries generated here anymore? And since I'm not in the country, my H-1B would still be valid one, right? The stamped H-1B.
It would still be valid. I'll give you a very interesting example. First of all, H-1 laws apply to you only while you are in the US. So while you are in the US working for the employer, they must obey all terms of US immigration laws. But let's say you stay outside USA for 6 months. Are they required to pay you a salary? No. Is your H-1 still valid? As long as there is still a job, definitely.
Okay, so that is a very interesting thing, because even if I go and they don't have to pay me, I know they will not pay me if I don't work here. So, but still, then we should not be questioned just because I'm not in the country. Then even if I don't have the salary slips, I should be able to file 485 whenever it is current.
485 you can only file if you are in the US.
Okay.
485 cannot be filed from outside US.
So, but at the time of the filing, sir, do they really need salary slips, recent salary slips?
First of all, how will you file 485? You have to be in USA, correct?
Okay.
So if you are in USA while you're not obeying the H1 laws, you entered on H1, you must have pay slips.
Okay. I mean, if we can do something like, enter, and then I can ask my, employer to, start my salary. Something
that
like
is definitely okay.
And, but if
I don't see any problem with that.
Sure, thank you. And one thing, if I do a consular processing, that's another where we can have it outside the country. The consular processing has to be done in India or Australia?
Consular processing can be done in India or Australia, either place.
Okay. And because that shows that I'm not in US, then at that point of time, I think salary slips won't be a problem, because anyhow they know that I was not in the country at the point of filing.
That is correct.
Okay. All right, sir. I mean, that's what I can think of. But I think the employer has to be very, very cooperative in this whole situation, where he should not, revoke my I-140.
And
the main thing is if they revoke my I-140, everything goes for a toss.
And they also have to be acting in good faith. They can't make things up. Okay? So if there is no job, they shouldn't say there is a job. That's fraud.
But the thing is, the job is there. I work in a EVC model, like at the client side.
Well,
So they know
I can only tell you what I see are the obvious difficulties in this situation. How you handle them depends entirely upon your employer, their lawyers, and you. Okay.
Okay.
Good luck to you, sir.
Okay.
All right.
Thank you, sir. Thank you.
Bye bye. California 805. Go ahead, please. Area code 805.
Hi, Raju. So I did file my green card as regarding comment number 21, by the way.
Okay.
So I did file my green card as a future employer, and I'm willing to continue with my current employer, which is not my petitioning employer. So if by chance my previous employer reports my case, or if any individual reports my case to you, sir, can that affect unfavorably?
Let me try to understand what you're saying. I'm not quite clear.
So if my previous employer reports that I have not joined them after my green card approval, would that affect my case in any way?
Your I-140 is approved through the previous employer, correct?
Yes.
Your 485 has been pending more than 180 days, correct?
Yeah, in fact, more than a year, yeah.
The job that the the green card job and the job that you are currently doing for another employer are same or similar, correct?
Yes.
Your old employer cannot do anything.
Okay, sounds good.
Okay.
And during naturalization, is it right that they look for only last 5 years of employment? So if I go for naturalization, say after 7 years, is it right that they're going to just look for last 5 years of employment?
Don't remember. I think that is correct. Look at the form N400. It tells you.
All right. And my last question is, my in-laws will be going for a B2 visa in the Mumbai consulate in India. So I suppose that won't be an issue if they find out that my employer after my green card approval is not the one which was my petition employer.
It's perfectly legal to be in your situation. AC21, no problem.
Yeah, I've not filed AC21, so...
You don't have to file. There is no law that says you have to file AC21.
Right. Okay, thanks, Rajiv.
You're welcome. Houston, Texas. Go ahead, please.
Hi, William. It's Anna. Question for comment number 14.
Hang on one second. Anna, did you say 14?
Yes, regarding the...
Yes, about B visa or F visa. I talked about it. Yes. Go ahead.
Yes. Based on the short term now on my H1 expiration in 4th of January 2014, do you have any specific preference on
Anna, I'm very sorry. I cannot hear a single word of what you said.
Can you hear me now?
A little bit better, but not a whole lot.
Now?
Okay, talk. Let's see.
Okay, my question is, considering the short amount of time between now and my visa expired date in January 14, do you have any specific preference between the F or the B as the best option to pursue?
So your question is, because I have so little time between January and now, do I have a preference? Well, remember, the law only requires you to file an application before your current status expires. So as long as you get your form I-539 filed before January, you are okay to stay. Okay, so you have plenty of time.
You think so?
I know so. This is what I do for a living.
Because that's not what my lawyers are telling me. My lawyers are basically telling me that there won't be any time to file for the I-485 between now and January.
What?
my lawyers, or I mean my employer's lawyers, because they are doing the job for me, think that I don't have any time between now and January to complete both the I-140 and the I-485.
No. That's not what I said. I'm sorry.
Okay.
Let me try to make it clear to you.
Okay.
I don't know if you have enough time for an I-140 approval. Okay. But
Okay.
if you file an application for F1 or B1 or B1, B2, you have enough time. As long as you get the application filed even one day before your status expires, you are okay. So you don't have enough time for I-140, but you have enough time to file for a tourist visa or a student visa.
Okay.
Okay.
Okay. Thanks.
You're welcome. Good luck. Okay, I have one more raised hand, then we can start new questions. Augusta, Georgia, go ahead, please.
Hi, Rajiv. This is Raj from the question number 19.
19.
You couldn't hear me before.
Right, now I can hear you loud and clear.
Okay, so I guess my follow-up question was that is it safe for me to go for a stamping to India while my labor is pending, because I'll be on my 12th year H-1B based on I-140 from an employer for whom I worked 6 years ago?
Well, typically, because the labor cert is pending, is no ground for worrying about H1. Okay, right now your H1 has been approved based upon the on the I-140 or based upon a labor cert?
No, the I-140 that was pending from employer number 1, whom I left in 2007.
There is no law that says you have to be working for them. I don't think that's going to be a problem.
Okay. So would it be safer that I wait for I-140 application before I go to India? You never know who's sitting behind the bench, right?
Well, I think it's okay for you to go anytime, but I must warn you, getting H1 stamping itself is difficult for everybody. I just think that having an I-140 from an employer that you worked for 6 years ago does not increase any problems for you as far as I can see. You want to wait for a new I-140 approval? That's fine. That's your choice. But I personally don't see any reason to worry about that.
Okay. And so can I go to Canada instead of going to India for stamping?
Yes, you can.
Okay. Any ideas on how long perm is taking these days if a new employer wants to file a fresh form for me?
People are telling me about a year, 6 months, 8 months to a year. The times are actually on our website.
Okay. And
the times are on our website. Also on my blog, there is an entry about 3, 4, 5, 6 months ago. Experience of one of the lawyers in our firm who went for H1 visa stamping to Canada. You can read that.
Okay. I think that's all I needed to ask. Thank you so much.
You're welcome. Good luck. Okay, guys, anybody has any question, press *5. Any question at all, new, old, doesn't matter. 1, 2, 3. Okay, 3 new questions. And that's all we'll be doing today then. No more after this. So this one is from an unknown caller. You must be calling from either voice over IP or your ID is blocked. Say hello.
Yeah, hi Raji. Can you hear me?
Yes, ma'am, I can.
Yeah, hi. I have a question regarding I-90.
Mm-hmm.
So USPS misplaced my green card, so I filed for I-90 and I received a passport stamp, which is a temporary evidence. So can I use it for anything, anywhere as a green card?
That is correct. The stamp that says approved for I-5 or pending I-551 processing, temporary proof of permanent residence, some such language, that stamp is as good as a green.
Yes.
That stamp is as good as a green card.
Okay. So I can use for entering the USA again and go to second employer, anything.
Anything. Only one caution. Sometimes if you go to other countries, like if you want to go to England, they may not know about this stamp. Other country entry might be an issue. But within the US or traveling back into US with that stamp is as good as a green card.
Okay, thank you.
You're welcome. Okay, 2 more questions left. New York, USA. Go ahead, please.
Hi, Rajiv. This is Bisak.
Yes, sir.
One quick request. I think there are 2 numbers listed on the conference numbers, but one of them it ends with 8395, and probably I think that's not working.
No, 8395 is for our personal client calls. That's not for conference. 8394 is the conference number.
Oh, okay. Sorry. I went on that call, so if possible, it's my question is question number 9.
9.
I can look at the call when you.
Well, I'll give you a
quick
quick summary if I can, but it's already recorded. Last name. What I said was, if when you filed her papers, you gave the right name, then obviously it's a USCIS error. They should correct it without the I-90. But if you gave them the wrong information, then you have to file I-90. Okay?
No, this is what happened. See, when we filed it, we didn't give a last name, so they issued, and then I checked with you, and then we changed the last name on the passport, and then applied so that for the advanced parole and the EADs, they gave it with the first name and the last name. But when they issued the green card now, they have issued in the original form without giving it as no given name.
If I were you, I would approach it as a USCIS error. I said do one of the following 2 things: either take an info pass and go downtown, or just call the customer service, see what they want to do with this case.
Okay. The one option is you can file an I-90 as a USCIS error and see what they say. That way.
No, take info pass and ask them.
Okay.
Okay.
And the issue is my wife is outside the country, so that's the.
She can enter USA on her advance parole.
Okay, and that was the second question. See, she has her advance parole.
Yeah, I have all this covered. I have all of this covered. Just listen to the recording. Don't worry, it's all covered.
Okay.
Okay.
Okay. One follow-up question. I think I joined when you were answering the third question. See, I had filed the AC-21 before the green card was approved, and the green card has been approved. Now,
I know your situation. I know your situation. I said you can get a letter from Company B saying that you can join in 2 months. You can continue working with Company A. I don't think you're going to have any problem.
Okay, even if you don't join, say in case the worst
even
case,
if you don't
have a job,
I don't think that's the problem. Even if you don't join,
but I would need some letter or correspondence from them.
You don't want to join them. That's fine. Stay with Company A. That's fine.
Oh, okay. That should be fine. Thank you very much, Rajiv.
You're welcome. Good luck.
Oh, thank you.
Last call, guys. Napa, California. Go ahead, please.
Hi, Rajiv. Rajiv, my question is the question number 8 on the forum.
I see it. Expand your business in India.
Expand business, by testing the US market.
Sure.
And send someone to US,
B1 visa.
Wanted to know what are the legal requirements around it. What do I need to do?
Actually, I answered that question. Maybe you logged in late. Real quickly, you can send.
I did. Sorry.
Yeah, I don't like to repeat myself. I'll give you a quick summary. Basically, you'll send whoever you are trying to send to USA to the consulate with a letter that explains what your business is. what you're planning to do, exploration of that business in USA. Make it clear that this person is an employee of your company in India. He remains an employee of the company in India. He will be paid his salary in India. In USA, you can pay him for his expenses and a small stipend. He will only be exploring, but he will not be engaging in any business per se. And once he does the exploration, then you intend to file proper visas to start your business in the US. Very difficult to say if it will work or not, but B1 is the way to go.
Okay.
Okay.
So once that exploration is done and he's starting the business, then I'll have to start a H1 or something for him, is it?
L1, H1, one of the two, depending upon what the circumstances are.
Right. And is there a investment threshold that's required to start a business or any other legal requirement that I need to?
There is no threshold for something like this. Whatever is genuinely required to start a business like this, that's all you need. You don't have to have X $1,000 or X $1 million investment. No requirement.
Okay.
All right?
Got it. And I mean, straight away start a L or H, and even to test the market, send the guy with the H or a L visa.
For H visa and L
Start
visa,
right
both of them, you would have to have an incorporation or a business set up in USA. And H1 is, of course, a little bit more complicated. L1 requires whoever you are sending has worked with you for at least 1 year, and either they are an executive or a managerial level employee, or they have some specialized knowledge of the company's very specialized proprietary work.
So my question was more particular about business setup in USA. So I think that's what I was trying to understand. What do I need to do?
Business setup in USA. Well, that's not really my field. You will need to talk with, best thing is to talk with a CPA, what we call CA in India.
Okay.
Talk with the CPA, figure out what the financial, and they can also tell you about the corporate details, or they can refer you to a lawyer, because here in USA, every state has its own corporate law. It is not like India where you have Uniform Companies Act, or UK where you have Uniform Companies Act. Yeah, here everything is per state. Every state has its own laws.
Right.
Okay, so that's the way you'll have to go.
So talk with the CPA or talk with a lawyer for that state that you want to incorporate.
That is the way to go. Good luck, sir.
Thank you very much.
You're welcome.
I appreciate your help.
My pleasure. Good luck, guys. Good talking with you, and I'll see you again in a couple of weeks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.